The Supreme Court usually releases its most anticipated rulings over several weeks or days. Not this year.
D.C., where the Supreme Court has narrowed the scope of nationwide injunctions.
The U.S. Supreme Court delivered a major decision today, one that will limit federal judges' power to block the president's agenda nationwide.
Justices have just ruled on whether a single federal judge has the authority to issue what are known as nationwide injunctions.
Following a Supreme Court ruling that limits the power of federal judges now to issue a nationwide injunction.
A single ruling issued in the dead of night just detonated the legal framework that every federal court in America has relied on for 20 years. And the fallout is already spiraling faster than anyone in Washington predicted. Late last night, the Supreme Court dropped a 6-3 emergency decision that is, without exaggeration, one of the most consequential procedural rulings in modern American history. Now, I know the word procedural makes people's eyes glaze over, but stay with me here because this decision determines whether a single federal judge sitting in one courthouse can freeze laws across all 50 states. And the answer, as of right now, is no, not anymore. The majority opinion draws a hard line. Lower court judges no longer have the authority to issue what are called nationwide injunctions, those sweeping orders that block state or federal laws everywhere, even when the lawsuit only involves a handful of people in one specific place. To put that in perspective, over the last decade, more than 60 of these nationwide injunctions were issued by individual judges. One person, one courtroom, overriding the decisions of entire state legislatures from coast to coast. The Supreme Court just killed that practice. And with 47 active federal cases currently seeking exactly this kind of relief, the dominoes are already starting to fall. But here's the part that legal analysts are only beginning to wrestle with, and it's the piece of this puzzle that could reshape American governance for a generation. The constitutional reasoning behind this ruling goes far deeper than anyone expected. Justice Gorsuch wrote a concurring opinion that essentially performs an archaeological dig through early American legal history, and what he found is devastating to the old way of doing things. He cites case after case from 1789 through 1850, 12 separate founding-era decisions, where federal judges were explicitly asked to issue broad relief beyond the party standing in front of them. Every single time, those judges said no, not because they lacked sympathy for the argument, but because they understood that the judicial power outlined in the Constitution simply did not extend that far. Justice Thomas took this even further in his own concurrence. He went straight to Article 3, the section of the Constitution that defines what federal courts are actually allowed to do, and argued that judicial power is limited to resolving cases and controversies. That phrase matters enormously because it means specific disputes between real parties, not abstract policy battles affecting millions of people who never set foot in a courtroom. Thomas essentially argued that the entire apparatus of nationwide injunctions was invented out of whole cloth by modern courts with no constitutional basis whatsoever. The dissenting justices pushed back hard, pointing to landmark civil rights cases from the 1960s as justification for broad injunctive power. But the majority responded with something that sent a chill through legal academia. They said those civil rights precedents, however noble in their aims, were wrongly decided on this specific procedural question. That single sentence is going to fuel law review articles and political arguments for years. And what makes all of this even more volatile is the speed at which the political world reacted. Within 3 hours of the ruling going public, attorneys general from 12 states had already filed emergency motions in their ongoing federal cases. Texas cited the decision in 3 separate immigration lawsuits. Florida invoked it in disputes over election law and social media regulation. Arizona used it in a border security case that had been stuck in the Ninth Circuit for 8 months. The velocity of these filings tells you that legal teams across the country had been waiting for exactly this moment, with briefs essentially pre-written and ready to go. Behind the scenes, the reaction at the Department of Justice was reportedly even more intense. Sources familiar with the situation say senior DOJ attorneys convened an emergency conference call at 7 in the morning to assess how this ruling affects their litigation strategy across 23 ongoing cases. The White House counsel's office began advising federal agencies to prepare for a scenario where state laws they believed were safely blocked by injunctions could suddenly snap back into effect, potentially within days in some jurisdictions. Republican governors started announcing enforcement plans almost immediately. Democratic attorneys general began scrambling to find alternative legal strategies to protect their constituents from policies they consider harmful. And caught in the middle of all of this is a question that should make every American pause. If the rights you can exercise depend entirely on which state you happen to be standing in, are those really constitutional rights, or are they just geographic privileges that shift every time you cross a border? That question becomes absolutely critical when you understand what this ruling does to the mechanics of how legal battles actually get fought. For 20 years, advocacy organizations on every side of every political issue have relied on a strategy called forum shopping. The concept is simple. You find a federal district with a judge who's sympathetic to your cause, you file your lawsuit there, and you ask for a nationwide injunction that blocks the policy you oppose everywhere. The numbers on this are staggering. Between 2017 and 2021, 78% of all nationwide injunctions against federal policies came from judges in just 5 districts. 5 districts representing less than 4% of the American population were effectively setting legal policy for the entire country. The Northern District of California alone saw 3 judges issue 19 nationwide injunctions in 4 years, more than the entire Fifth Circuit produced in the same period. That strategy is now dead, and its death has enormous practical consequences. A case that used to require 1 filing in one friendly courthouse might now require 15 or 20 separate filings across different circuits. Each filing needs its own legal team, its own arguments tailored to local precedent, its own appeals process if things go sideways. Major law firms are already circulating memos to clients warning that the cost of civil rights litigation, environmental challenges, and constitutional cases could increase by 5 to 10 times overnight. But the financial burden is almost secondary compared to what this means in areas where the stakes aren't measured in dollars. They're measured in human lives. Immigration enforcement is the most immediate flashpoint. Right now, ICE operates under 14 different injunctions that restrict various aspects of deportation policy, detention conditions, and asylum processing. Under the new framework, many of those injunctions may only apply within the specific districts where they were issued. That means federal immigration authorities could resume full enforcement operations in every other part of the country, potentially within 30 to 60 days, as lower courts issue clarifying rulings. Second Amendment cases face a mirror image problem. Gun regulations in 6 states are currently frozen by nationwide preliminary injunctions. If those injunctions get narrowed to only protect the named plaintiffs, state officials could immediately begin enforcing firearm restrictions on everyone else. Your Second Amendment rights could literally change the moment you drive across a state line. Healthcare access is another massive pressure point. 11 active cases involve nationwide injunctions related to abortion medication, gender-affirming care, and religious exemptions to insurance mandates. If those injunctions shrink to cover only specific plaintiffs or specific districts, the patchwork of healthcare access across America becomes almost impossibly complex. Environmental regulation faces the same fracturing. The EPA is currently blocked from enforcing clean air rules, water protection standards, and climate-related regulations by injunctions that could now be geographically limited, meaning the air you breathe and the water you drink might be governed by different federal standards depending on your zip code. And then there's the issue that could throw the entire country into chaos at the worst possible moment. 9 nationwide injunctions currently affect voter ID laws, mail-in ballot procedures, early voting rules, and voter roll maintenance across 19 states. Under this new framework, those injunctions might only protect voters in the specific counties where the original plaintiffs reside. The same state election law could be enforced in 80% of a state while being blocked in the remaining 20%, purely based on where someone happened to file a lawsuit. Election administrators need months of lead time to train poll workers, print ballots, and configure voting systems. The National Association of Secretaries of State issued a statement this afternoon expressing what they called serious concern about operational chaos if injunction boundaries shift right before major elections. And the bitter irony is that both political parties have relied heavily on nationwide injunctions to challenge election rules they oppose. Between 2018 and 2023, conservative groups obtained 8 such injunctions while progressive organizations secured 11. Both sides just lost their favorite weapons simultaneously. The business world is quietly spiraling too. The U.S. Chamber of Commerce estimates that compliance costs for companies operating across multiple states could jump by $47 billion annually if they need to maintain different operational standards based on which federal regulations are blocked in which districts. Banking, technology, healthcare, pharmaceuticals, employment law, every sector that depends on regulatory uniformity is staring at potential fragmentation. Civil rights organizations have raised perhaps the most emotionally compelling objection. The NAACP Legal Defense Fund pointed out that during the Civil Rights era, broad injunctions were essential to enforcing desegregation. If Brown v. Board of Education's implementation had been limited to only the specific school districts where plaintiffs filed suit, the dismantling of segregation could have taken decades longer. Modern civil rights cases face the same dilemma. When a state passes a law that discriminates against a protected class, should the court's remedy only help the few individuals brave enough to put their names on a lawsuit, or should it shield everyone facing the same harm? The majority opinion sidesteps this tension entirely, focusing on Article 3's structural limitations, regardless of how sympathetic the underlying claims might be. Disability rights advocates have flagged particular concerns, noting that the Americans with Disabilities Act has been enforced primarily through broad systemic injunctions. It remains deeply unclear how effective enforcement works when relief is limited to individual plaintiffs. What's really happening beneath the surface is something even larger than the injunction question itself. The Supreme Court is reasserting dominance over the entire federal judiciary in ways that would have been unthinkable a generation ago. By issuing this ruling through the emergency docket rather than waiting for a full case with oral arguments and extensive briefing, the court sent an unmistakable signal. Comply now, not after years of additional litigation, not after further debate. Now. This fits a clear pattern. Over the past 3 years, the court has issued 47 emergency orders modifying or vacating lower court decisions, compared to just 19 in the preceding 3-year period. These shadow docket rulings typically contain minimal reasoning, forcing lower court judges to guess at the Supreme Court's intent rather than following detailed guidance. Several appellate judges have privately expressed frustration, saying this approach creates more confusion than clarity. The practical result is a Supreme Court that is micromanaging federal litigation from the top down, reaching into district courts and circuit courts to correct what the current majority views as decades of overreach. Whether you see that as a necessary correction or a dangerous consolidation of power depends on your perspective. But the reality is undeniable. Hundreds of federal judges across America just got told they've been doing their jobs wrong for 20 years and they need to change course immediately. The consequences of this ruling will unfold over months and years, touching immigration, gun rights, healthcare, elections, business regulation, civil rights, and the fundamental question of whether we operate as one nation under one legal system or 50 separate jurisdictions with 50 different versions of constitutional protection. That's it for today, folks. See you in the next video.